Hi, my name is Andrews, and welcome to another episode of the Shaft podcast. On this episode, I'm going to do a second version of the discussions around the Speaker of Parliament, his declaration of the 4 vacant MP seats, and the matters that have unfolded from there up until this point. Just a side note, if you really like the Speaker, maybe you'd not like this episode, because on this episode, I'm going to be extremely critical of him and critique majority of the things that have been seen from yesterday's press conference of the Speaker to now, because it's not been great. And I think that he's starting to become the problem within this whole chaos, and it's getting out of hand. I mean, the two caucuses in Parliament were misbehaving and being immature, and I think Mr. Speaker is getting in the mud and it's getting out of hand. And so join me, let's break things down, and let me walk you through why I hold these opinions. First, just to let you know, I recorded an initial episode of this when I titled it The Speaker's Gambit, and it was more important, and that title was very deliberate because ultimately what I saw after analyzing the issues that were happening was that it was simply a chess game of egos that was ongoing. Mr. Speaker felt he had power, parliamentarians felt they had power, the Supreme Court felt they had power, and everybody's egos were just flying high. Now, what I'm going to do is to break down as to how this chess game has evolved, and now it's becoming one of those games where everyone is losing, no one is winning, and it's becoming absolutely terrible. So today, the 7th of November, Mr. Speaker, Right Honorable Alban Bagbin, has again indefinitely suspended parliamentary sittings and parliamentary proceedings. He did it the last time, which prompted my initial episode. He's done it again. And this time round, his reason is not that there is not enough people to make decisions in Parliament. He says that there is no business at all on the order paper to be discussed. Why? Because the committee in charge of business did not meet to deliberate to bring him or to bring to the House issues that have been settled upon to be discussed in these proceedings, which meant that there was nothing to be discussed in the House. They had just spent fuel, come to the House for nothing, and he had to indefinitely suspend parliamentary proceedings. Now, in going through this conversation, there are a few things I want you to note. One is that the Speaker is a lawyer, and so this is very important for the context of things that I'm going to explain and how they've happened. But secondly, I'm starting to realize that the Speaker is frustrated, probably by things that have happened over a long spell, and this is the point where he's at his cap. And so sometimes if you want to understand some of the decisions and some of the considerations that he's making, and you are just situating it within this context, it might feel unreasonable. But if you look at it from the perspective of, look, I think this person is frustrated, he's feeling underappreciated, and he's starting to believe that he needs to stamp his authority on things, then it gets much more interesting. But also the fact that the Speaker is a lawyer, so he's showing his legal prowess and flexing his legal muscles in bits and pieces. So first, let's talk about the things that have happened after the initial preview that we did. So after the initial preview that we did and the analysis that happened, it ended at the point where the case had been filed at the Supreme Court, and the Speaker had been ordered by the Supreme Court and notified of proceedings to set aside the execution of his ruling. Now, here's what happened. The Speaker, obviously, at that particular sitting, suspended parliamentary proceedings indefinitely because he said there were not enough people to make decisions or to take decisions. And so what he then did was to send his lawyers to file a case in court. And the case in court was to plead with the Supreme Court to set aside their ruling that was barring his execution of the kind of ruling that he gave in Parliament to declare those seats vacant. And the case that was being filed was on several grounds, but one of them being that the Supreme Court was not the right jurisdiction to be making these determinations. And so let's look at the issues that were dealt with. In that case, what the court came to conclude on and how we've gotten here today. So first, let's talk about the issues that were dealt in court when the Speaker filed a counter case to the Supreme Court. There are a few things. First, there was a preliminary issue raised by the Speaker's lawyer, Barrister Sorry, who then made the case that there is a member on the bench, a member of the Supreme Court on the bench, who is a known affiliate of the NPP. In fact, at a time, purported to run for parliamentary seats for the NPP, and therefore they are requesting that that person recuses themselves. Now, the Supreme Court deliberated on that matter, came back and said it wasn't necessary, mainly because first, this person had been vetted in Parliament. Parliament is where you need to bring these things up and maybe deny them. But once you've passed them to the bench, that is not the place where you come and debate the political identity of the person. Secondly, that person has risen above those political identities and has been vetted and approved as a judge of the Supreme Court. And therefore, he cannot be denied the ability to sit on the bench for certain cases. And so that issue was set aside and that request was denied. Now, the issue that the Supreme Court had when it came to the Speaker's request was decided on 3 levels. So let's go through them. First, there was a question as to whether or not the Supreme Court had the jurisdiction to hear the case. And the most important thing is that the case that was being filed was a case to seek for a constitutional interpretation as to whether or not the provisions in the Constitution actually mean that when a person is in Parliament and that parliamentary term has not ended and they decide to contest in the future election on the ticket of a different party or a different political identity, they should be made to vacate their seat. So that's basically the issue. The Afenyomakin's case in the Supreme Court is mainly to check what does the Constitution really mean when they say that when these things happen, cause them to vacate their seat. Does it mean that in the next parliament? Does it mean in the current parliament? And so that's the confusion that they have around some of the issues that the Constitution had laid out, especially with the clauses. Now, the most important thing then is that does the Supreme Court has the jurisdiction to hear this case? Now, the Supreme Court ruled on this and said, yes, they do. And it was right for Afenyomakin to come directly to them and file the case in the Supreme Court, because the Speaker's issue was that these cases are typically filed in the High Court instead of coming to the Supreme Court. And the Chief Justice made a really unique example when reading out her ruling. She said, look, if there's an election and there's a dispute about whether or not the process to winning that election had been followed, then that goes to the High Court. Why? Because that process is already agreed upon. The only debate is whether or not that process was followed. So there's not a discussion as to what is the process. There's only a discussion about the fulfillment of that process. And so that goes to the High Court to determine. And so the High Court determines based on preset agreed constitutional provisions and the fact that everybody understands the meaning and the rationale behind those constitutional provisions. If in that same election dispute, the contention is not that a process was not followed, but that the process is unconstitutional to begin with, that suit would then have to come to the Supreme Court, because then the question is not whether or not an agreed constitutional process was followed, it's whether or not a process was constitutional to begin with, and it is the Supreme Court that determines matters of constitutionality. Therefore, even if you file such a case at the High Court, they would pause and refer it to the Supreme Court to determine the proper constitutional interpretations before it gets back to them to then proceed with whatever case that they were going to proceed with. Which meant that even if Afenyomakin had gone to the High Court and applied that, look, I want you to do this to Mr. Speaker, I want you to check whether or not this provision is interpreted this way or that way, the High Court would have had no option than to refer it back to the Supreme Court to make this constitutional interpretation. What this then meant was that it was within the jurisdiction of the Supreme Court, and it was actually probably one of the things that only the Supreme Court has the capacity to do when it comes to legal issues. And so constitutional interpretations are reserved for the Supreme Court, and that is very, very important. And I think I don't know a lot about how they determine properly, But I know that, for instance, some of the steps that they take is that they go back to read parliamentary minutes on when these bills were being debated, when these laws were being put in place, to understand the rationale of parliamentarians when they were making these determinations, to be able to know what is a true and proper interpretation of these provisions within the Supreme Court in order to make their ruling and apply contemporary context as well. The second thing that the Supreme Court ruled on was the jurisdiction of the court and whether or not this time round the jurisdiction had been properly evoked. Now, the Supreme Court then says there were a mixing up of the two things in the case that was filed, but they should be separate issues. Why? Because the existence of a jurisdiction is different from whether or not the jurisdiction has been properly evoked. First, the jurisdiction exists, and so that means that they are eligible and they have the right and the capacity to hear that case. As to whether or not the jurisdiction has been properly evoked, that's a matter to be determined during the substantive proceedings, and so that would be determined on the 11th or after the 11th of December, after the Speaker files his proceedings to the case. But the third thing was then the Speaker was requesting for the court to set aside their basically the ruling that they gave out initially for the Speaker to hold the execution of his ruling. And so the Speaker ruled that, look, these seats are vacant. Now the court sent an order saying, hold on to the execution of these seats up until the matter is determined. So do not make these seats vacant up until the matter is determined. And then the Speaker goes back to court to say, set aside that ruling or that order that you brought to me so I can go ahead and do my thing. And the court denied that as well on the basis that setting or declaring those seats vacant has huge impacts on people, on the constituencies who are not going to be represented for the rest of the year up until January 7th, for these parliamentarians who will be losing their jobs instantly, for some of them who are ministers who are going to be losing their jobs, specifically if they were appointed ministers because they were members of parliament. And so you look at these things and it's like the court's rationale behind it is the impact are too huge and too significant to allow those orders to be carried out when the substantive case of whether or not these orders are even constitutional to begin with, or are even based on the right constitutional interpretations to begin with, have been followed. And so that's what we saw when it came to the ruling. Now they gave the Speaker up until the 11th of November to file his proceedings. So we are still waiting for the Speaker to file his proceedings. But there are a few things that have happened since then. First, the Speaker held a press conference yesterday. Now, there are a few things that he said in the press conference that I vehemently disagree with, and I'm going to walk through them one by one and point out why he's starting to become the problem in this issue instead of trying to resolve the problem. First, he says he believes in the supremacy of the Constitution and not the supremacy of the court, which is to say, it's just a simple, let's just be frank with ourselves. It's another way of saying, I don't think the Supreme Court should have the power that it has, or I don't respect the powers of the Supreme Court that much. And that is ridiculous because literally you are the one who is supposed to embody what the laws of the land require us to do. And if you are the Speaker of Parliament, the chamber that makes laws, and you are publicly declaring statements like, I don't believe in the supremacy of the court, when you clearly know, regardless of how much you dislike rulings of the court is still having the power to execute it. And I get it. Maybe we can have a philosophical debate someday about whether or not courts should be actually empowered to the degree to which they are empowered in a democracy. That's an independent conversation to whether or not within a pragmatic setting where the courts are empowered by that to that extent in the Constitution, you as the Speaker of Parliament should sit publicly in the press conference and then say, I do not think that I believe in the supremacy of the court. I only believe in the supremacy of the Constitution. Obviously, the court and the Supreme Court specifically is the institution that is empowered to interpret the Constitution and determine exactly what it means for all of us. And so that is very, very important. He shouldn't have said that. I think that's a wrong statement to make. No matter how subtle or inferred you think this explanation is, it was obvious exactly what he meant with the context and with the developments in the country. That was a bad call for the Speaker of Parliament. Secondly, he says that logic that he basically presents the case that, well, there were certain happenings in the past where he had declared certain seats vacant, like Adjoa Safo's seat that was declared vacant, and Kennedy Japan, and some people who had missed parliamentary sittings for a very long time. And he's claiming that, well, those cases were never sent to court. So why are these ones being sent to court? Yeah, sure. It doesn't mean that these ones being sent to court makes it wrong, right? Obviously, we don't know. Up until now, that's what the case is about. The Supreme Court is supposed to determine whether or not these haphazard declarations of seats as vacant is right, whether or not they've been done since the establishment of the parliament, since the establishment of the constitution. If indeed the Supreme Court determines that they are wrong, it doesn't make the fact that they've been consistently done in the past right. And so, as a speaker, you cannot defend yourself or defend your actions by saying it's consistently been done in the past and no one complained. Yeah, sure. Maybe everyone has been sleeping when the wrong thing has been done over and over again. Now people are awake. At least it's fine. Let's find out whether or not we've been doing the right thing or the wrong thing. This whole, like, sometimes just weird and ridiculous cry outs of some foul play when the case itself is obviously there are political intentions behind the case. I'm not going to be naive about it, but the core of the case is to find out the validity of a constitutional interpretation, because there are varying opinions as to what that constitutional provision actually means. And so that conflict means that we need to settle it in the court that determines what a constitutional provision means, or at least not determines, but finds out for all of us what a constitutional provision means. And so when people are doing that, you don't come back and say, yeah, we've done this in the past and nobody has complained, so why are we doing it now? It's a very bad approach to the conversation as the Speaker of Parliament. And that was one thing I really didn't like about his press conference. Then the next thing he says, well, the Supreme Court said, they are holding on to his ruling because the South constituencies, who are like 4 constituencies in the Volta region, did not have parliamentary representation for years, and the Supreme Court didn't do anything swiftly about it. Yes, and that's a very terrible thing that the Supreme Court has done. They've not swiftly acted on the absence of representation for huge numbers of people in 4 constituencies in the Volta region. It doesn't mean let's add another 4. It doesn't mean let's create more. And so, Mr. Speaker, the solution to the Supreme Court being terrible and not acting swiftly on the absence of representation for the 4 constituencies under the South case does not mean it should be fine for them to not do it another time. And so what you would say is, which I agree with in the part of the case that he says, the part of the press conference where he says the Supreme Court should apply the same swiftness to some cases like the South case. Fine, but do not justify the absence of them doing it in the South case to then import that justification to say, well, then they shouldn't do it now as well. Like, I think that's a really bad interpretation of the things that are happening. And then there are a few more things that he did that I really think was just below the belt. So, for instance, a question was asked about the Attorney General. Then he resorts to the age card. And as somebody who is young, I really dislike it when people resort to age cards to try and explain why somebody's wrong or somebody's right, because his age card was obviously pointless. It was just directed at trying to undermine the Attorney General just because he's young, because he says, well, he was in Parliament, the Speaker was in Parliament, and in the leadership of Parliament when Godfred Dame came to Parliament to do his national service. And so what? So what? He came to Parliament to do his national service. So what? It has nothing to do with his intelligence. It has nothing to do with the rightness or wrongness of whatever position he's taking. So let's stop in this country using age cards to try and undermine people. It is annoying. It is not fruitful conversation, and it's not going to take us anywhere. As somebody who is parading to, or who is trying to champion proper discourse in the country, this is not the tangent of proper discourse. Let's try and be better with ourselves. Because yesterday, listening to this part of the press conference, I was really, really fuming about just trying to undermine people by certain unrelated conversations. And that's very bad conversation. And a lot of our leaders do that. A lot of our leaders, instead of having the actual conversation, deflect by undermining people using unrelated characteristics or attributes that have no bearing on the case that is being discussed. And I think we should start to do better as a country. But then the main case about the Attorney General, actually, because the Attorney General said the Speaker's lawyer has been illegally procured. And so that's illegal itself. Because, sorry, the speaker's lawyer, who is, I've forgotten his first name, but he's named Mr. Sorry, who is representing the speaker. The laws say that if the Speaker of Parliament is going to contract the services of a private legal practitioner, then he should go through public procurement processes, right? Because it's private procurement. And so he didn't go through public procurement because he says he applied and he was told to go through the Attorney General's office for representation. And the speaker's explanation is, yeah, but how can I be represented by an Attorney General who is against me on a case? First off, that's a very huge misrepresentation of whatever is happening. The Attorney General did not file a case against the Speaker. The Attorney General is only on that case because by law, anytime an issue of constitutional interpretation is filed, the Attorney General is automatically enjoined as a party. As a party on the case does not mean that the Attorney General's office cannot represent the Speaker's office and assign a lawyer to represent the Speaker just because he's enjoined as a party. He doesn't have an interest. The Attorney General does not have an interest. He has an interest in terms of the constitutional provision. And so for that one, I disagree with the Speaker. And sure, you might say the Attorney General is appointed by the NPP. Fair enough. You might have your skepticisms, but it doesn't validate the opinion of the Speaker on this one. You might have your concerns about whether or not the Attorney General will be looking out for the best interest of the Speaker or whatnot. But also, more importantly, this is not a case of individual human parties. This is a case of interpreting the Constitution. So regardless of who your lawyer is, it is not a case of the Speaker needs to be defended and Afenyo Makin also needs to be defended because one person will be declared guilty and one person will be declared innocent. No, that's not the case. It's not a criminal case to declare guilt and innocence. It's simply a case of constitutional interpretation, which means that it does not matter. And so the Speaker is not a party, is not, so to speak, a party. The only party in this instance, which the Attorney General explains clearly, is the Constitution, because this is a matter of constitutional interpretation. So regardless of the interest of those two persons who have been joined on the case, it's about what the Constitution means and not whether or not someone is right or wrong, or someone is guilty or not guilty. And so that approach by the Speaker, again, was wrong. And he clearly, and to be very honest, and that's why I said the Speaker is a lawyer. He knows what he's doing. He's playing with the parliamentary rules and he's playing with the Constitution, and he's using the nuances that he wants or he sees to create his own discussions. And so obviously he's maneuvering his way around these things. And that's why I'm saying that he's just playing the chess game. And at this point, everyone is losing. Even he himself is not winning. And so it's becoming annoying and becoming frustrating. Then he says that Chief Justice and the President has sinned. But more importantly, he says that the court and the Supreme Court has the power to change their decision. And so it doesn't mean that the court is always right, because for an institution that has the power to change their decision, why should we consider their decisions to always be right when in the next years down the line, they can change their decisions? And that, for me, again, was insinuating that he doesn't respect the orders of the Supreme Court that much. Yet, in that same press conference, he's pleading with the Supreme Court to do things, to be very, very swift in executing certain things and determining certain cases and all that. Like, how can you disrespect the court in one breath and then in the second breath expect them to take swift action on certain issues because you think those ones would benefit you? I think these are like games that we should stop playing. And the Speaker knows all too well exactly what he's doing. He's a very intentional person. He's a very intentional man, but he should start behaving in a way that helps the progress of these situations and help to resolve them. But finally, then he says, well, and this is one thing that he said that was very alarming for me, which makes me question the very democracy we are even living in as a country. And for this one, I blast every single person, from the majority leader to the minority leader to the Speaker himself. He says, and go and listen to his press conference yesterday, he says that they sit and hold pre-agreement meetings before a session. Every single parliamentary session in the last 4 years, he sits with a minority and majority leader. They agree in the room on things that they are going to do, how they are going to vote, how things are going to play out on the floor. Before, when they are in the chamber, they basically just communicate exactly the things that have been agreed on and nothing more. And so if you don't do that, right, And so if you don't do something that you've all agreed on in the pre proceedings meeting, then they are going to call you out for it and going to take some actions that would undermine you in certain ways. This is just telling the entire country, right? And I know you all missed it. It's just telling the entire country that when you vote representatives to go to parliament, they don't do anything. The leaders of their groups and their caucuses go and sit with the speaker, make a predetermination, come and impose on it to the House. And so your parliamentarians are not representing your interest. They're not looking out for you. They're not speaking about things that are contextual and specific to them. That is extremely bad democracy. Why? Because you are representing people, but you can't speak on their behalf because there have been pre-agreements and there have been pre-meetings and ridiculous compromises reached, which means a lot of your parliamentarians are just there to create numbers to pass decisions and meet parliamentary quorum. And that is really, really bad. And that's alarming for our democracy because we claim we are representing people, but we find ways and means to undermine the very authenticity of that representation in ways that are so alarming. And so for me, that was one of the mind-blowing things I heard the speaker say at the briefing, the press briefing yesterday. And it's with the comfortability that he says it. It's with the comfort that he says it. Like, it means all the debates that they have in parliament are manufactured debates. All the things that they say in parliament are like pre-agreed and pre-manufactured decisions. What is happening? Then we claim we really want to represent people. This is really bad. And I think the speaker is muddying things even more with this whole trying to distance himself from the ruling and from who is majority and minority and blaming everything on anyone else except him. Like, yeah, everyone else is at fault, including the speaker. No one is guilt-free in this process. And that's the sign of someone who is guilty when he's not willing to even take responsibility for anything that has gone wrong, knowing clearly there are certain things that he is responsible for. I think the speaker should do better. And on this note, thank you for listening in. Thank you for joining the second episode of the Speaker's Gambit. I'll be back after the ruling of the substantive case to give you more breakdowns. Thank you and see you on the next one. Do well to subscribe to the Shaft podcast and let me know your thoughts on this issue. Bye, guys.